In January of 1968, I contacted Bob Critchfield, whom I had worked for during my first year, or between the summers between first and second years of law school, and asked him if I could have a job, and he said yes. And they were the building that the firm is in today was under construction. Actually, it was just being finished up in January of '68, and by the time I moved to Wooster in April of '68, it was finished. So I was able to move into a brand new office.
And did Critchfield ask, so you're with this fancy Washington law firm, why do you want to come here?
Yes, and I told him about that transcript. And he understood in a second. And another reason was that I had hankerings to someday become a congressman. And you can't be a congressman from Washington, D.C. They don't have any. So coming back home, now, I was a little naive about it because Wooster, Ohio is not very Democratic, and I was clearly in the Democratic column, so...
what did give you those hankerings to become a congressman? I mean, a lot of people don't grow up think I want to become a congressman.
I just had read about how our government works, and I had been a member of, I'd gone to the National Student Congress, where the whole week that I was down there in Miami, we talked about various kinds of legislation that might be proposed for the United States government, and I found that fascinating, and I thought it would be interesting to be a congressman. Don't ask me where that notion comes from. But that was one of my ideas about moving to Worcester. And the Critchfield Law Firm, when I joined it, was 6 partners and me. And long prior to me coming to Wooster, the case of Gideon versus Wainwright was decided by the United States Supreme Court, stating that every indigent defendant was entitled to have the state supply him with a lawyer. And it took a while for people to catch on to that idea, but they did. And the common pleas judge at that time here in Wooster, Adrian Miller, decided that indigent defendants that came before him should have a lawyer. And his way of solving that problem was that he had a list of all the lawyers in Wayne County. And when an indigent defendant would come before him, why, he had crossed off the names of people he had assigned, and the next guy on the list was the person that got the assignment to that person, and he would get a call from the judge's secretary telling him that probably the client was in jail and they should go visit him. Now, the 6 lawyers who were partners at the Critchfield Law Firm had better things to do than to represent indigent criminals. So when Adrian would assign one of them to a criminal case, they would quickly assign me to the criminal case. And so I got all the criminal cases assigned to the Critchfield Law Firm. So instead of getting one assignment every once in a while, I'd get 7 assignments every once in a while, would start added up to quite a practice. And that was one of the ways that I learned to be a criminal lawyer. And just being in a small town and criminal cases would walk in, the guys in that law firm were not interested in doing divorces or driving while intoxicated cases or any of the more run-of-the-mill kind of cases. So a lot of those got assigned to me, and the great difference between working for Arnold and Porter and working for the Critchfield Law Firm was that I got real people as clients. Ben Heineman was not a real person. He was unreal.
When you were in law school, had you thought about, who you want, what sort of clients are the ones that are going to appeal to you?
I did, and well, for example, I did very well. Well, I got the highest grade in labor law, and I thought representing either management or labor in labor disputes would be fascinating. Never got to do it. Yeah, the way it actually works is you get the clients that walk in the door. I mean, I would have enjoyed doing a medical malpractice case, a good one. One never walked in the door. I mean, so you do the kind of work that is there to be done. Mm-hmm. And so, and the Critchfield Law Firm had lots of big clients, and I learned a great deal about oil and gas law because John Wiggum, one of the partners, his office was right next to mine, and he had a huge oil and gas practice, and I did a lot of, I helped him a great deal with his work. And Wayne County is one of the centers of oil and gas activity in the state of Ohio. So there was a fair amount of that kind of work. And the final case that I did for the Critchfield Law Firm was one of the most difficult cases I ever encountered. It was a very nice lady in her early 30s who had 4 lovely children, and she and her 4 lovely children were out driving one day, and they came up to Route 30 and they stopped, looked both ways, didn't see anything coming, pulled out, and a motorcycle ran into the side of her car with predictable results. And so she was charged with traffic manslaughter. And so she retained me, and I asked for a jury trial. And the thing that made it so difficult was it was absolutely clear that she was guilty. But it was also absolutely clear that putting this nice lady in jail was not going to advance the social order in any way, shape, or form. So I've always said that in criminal cases, people say, how can you represent somebody that's guilty? I'd much rather represent somebody that's guilty. At least if we lose, it's okay. Representing somebody, the worst is somebody that's guilty where going to jail would be a terrible idea. And So I tried to get rid of everybody on that jury that had even looked cross-eyed at a motorcycle. And I managed to get, I didn't have anybody that owned a motorcycle on the jury, but I had 3 or 4 people who had ridden a motorcycle once or twice, or at least that was their testimony on voir dire. So that was what we had. And we tried the case, and we ended up with a hung jury. And what we had was a case of jury nullification, which means that the jury figured, the members of the jury that had never had any experience with motorcycles all wanted to acquit her because they figured out that putting this nice lady in jail was not going to advance the social order. And everybody that had even ridden a motorcycle once wanted to convict her. And they came back, told the judge, they didn't put it in terms of who was voting which way, but they told the judge they were hung, and he sent them back and told them to work harder and all that kind of stuff. And eventually, it got to be fairly late in the evening, and they came back and said they were still hung, and so the judge called us up to the bench, and he says to the prosecutor, "Frank, you dismiss your charges. I'll find her guilty of failure to yield. We'll fine her $50, and we'll get rid of this case." And so that's what we did. And that's always been one of the more satisfying results that I ever got, because it was just exactly the right result, which had never occurred to me. I probably worried about that case more than almost any case I ever had.
Did you feel with the criminal cases that responsibility felt more human and more consequential than, say, the railroad cases?
Yes, absolutely. What I really liked were cases that involved real people with real problems, and like a divorce case. I mean, most lawyers don't like divorce cases. I found them fascinating, and a person who shows up in your office and says that their spouse has run off with another person, now that's a real problem. And of course they come into your office with the idea that what their idea of a good result is that what they want me to do is go out and grab the rascal by the neck and bring him back and put him in the get him to sit down at the dinner table where he belongs and stay there. Which, of course, is not the kind of result that I can offer. And you have to convince somebody they don't want to be married to a person that doesn't want to be married to them. So we've got to sort these things out. And it's difficult.
So there's a bit of social work involved.
A trial lawyer who isn't a psychologist should not be doing that. It involves a lot of psychology, and I enjoyed that. I enjoyed helping people sort through problems that seemed very, very difficult. Another kind of case I had. Well, I did a lot of criminal cases. Marijuana was just becoming popular at that time, and the war on drugs was just starting. And the notion of trying to prove that marijuana was marijuana became very challenging for the police. And putting together a chain of evidence became very challenging. And so I had a lot of success with marijuana cases. For example, I remember specifically one case where the the detective testified that he had taken my client's bag of green vegetable matter and delivered it to Miss Beavers at the Bureau of Criminal Investigation. And then here comes the chemist from the Bureau of Criminal Investigation, gets on the stand and testifies that he had gotten this bag of green vegetable matter from the Wooster Police Department. I object, Your Honor, that's not my guy's stuff. They gave that to Miss Beavers. End of case. I had another case down in Mount Vernon, and this clearly was a tough case. So the chief of police in Mount Vernon testified that he had personally tested my client's bag of green vegetable matter, and he had used a kit that he had gotten from a laboratory in California, and the instructions said that if the green vegetable matter in the tube turned purple when you put some chemicals on it, why that it was meant it was marijuana. And so he did that, and it turned purple, and so he was there to testify that it was marijuana. I said, Your Honor, I need to cross-examine the people from that lab in California. How are we supposed to know whether there's any accuracy to? It's all pure hearsay. The judge said, well, you're right about that. So the case got thrown out.
Because they weren't about to bring the people from California in.
Right, exactly. So, and I tried, I learned how to try a jury case when I was with the Critchfield Law Firm. Those guys sat second chair with me and helped me try a couple of cases. And the first jury trial I had, I lost. I don't think I should have, but I did. The second jury trial went much better, but I don't know what the issue was. I don't know what the question was, but I asked I did what every young lawyer does. I asked one too many questions. And I got a terrible answer, and I'm standing there trying to figure out what to do next, and the judge goes, Mr. Noble, would you please approach the bench? So I go up to the bench, and the judge, before the other guy can get around the table, the judge leans over and says, David, that's what I call an oh shit. And I go, Your Honor, I'm having enough trouble without you harassing me. The other guy came up there, and the judge just flicked his hands and said, you go back and sit down. But I got a very nice verdict in that case. And the thing that was unbelievable was that the rules had changed just before we tried that case, the rules of civil procedure. And under the old rules, if you filed a notice of appeal, there was an automatic stay of execution. Under the new rules, one has to file a supersedious bond in order to obtain a stay of execution. That's a bond that says that if they lose the appeal, then the verdict will in fact get paid. And but the old insurance lawyer that tried the case was a personal injury, automobile accident kind of case. Didn't know about the new rules. So he filed a notice of appeal blithely thinking that stayed execution, but it didn't. So I issued a precipice for execution. The defendant in that case was a factory worker down at the Wooster Brush, and told the sheriff to go on and pick up his car. I told him he worked second shift at the Brush. Of course, the guy comes out of second shift, doesn't see his car, calls the police, tells them he's reporting a car theft, and they said, "Oh no, we know where your car is. The sheriff's got it." Well, that guy couldn't. The lawyer for his insurance lawyer could not come over fast enough with a check and the full amount for the verdict.
And so he gets his car back.
And the guy got his car back. That was the whole idea. he was just a little bit embarrassed. And then on July 5th, 1969, there was an enormous flood here in Wooster. The skies opened up at 9 p.m. on July 4th, 1969, and rained steadily an inch an hour for 12 hours. And all the creeks were over their banks. There were, I think, 27 people were killed.
Mm.
And I spent the day of July 5th in a police car, just riding with a police officer to be there to provide any assistance that I might be able to provide. And one thing the two of us did was we pulled a 12-year-old boy out of a tree, and he had been on a boat that another police officer had been in, plus a bunch of people they were trying to rescue down in the Bower Road area, and the boat and everybody else they were all killed.
Mm.
They all drowned, except for this boy that we found in this tree. And it was a devastating time for Wooster and Wayne County, and I ended up with another railroad case. The flood wiped out the bridges between Fredericksburg and Holmesville, and the railroad from Columbus to Akron went through Orville. The Conrail filed an application with the ICC to abandon service from Howard to Orville. And Fredericksburg and Apple Creek were just a little bit upset about that. And so we opposed the abandonment, and I had several people from Fredericksburg and Holmesville to testify about various problems that would be caused by no longer having a railroad. Unfortunately, the cost of putting those bridges back was more than the Interstate Commerce Commission thought the Conrail could afford, given the sparse level of traffic on the railroad. They did require them to keep it open to Holmesville because a Dressograph Multigraph was there and they needed the railroad. But my clients did not get the railroad back, and it's still going.
And how did that impact that? I mean, is that?
Well, the owner of the mill in Fredericksburg testified that he was going to go out of business without the railroad. Somehow he's still in business to this day.